Hello, everyone. I would like to call the meeting of the Board of Appeals to order at 5:32 p.m. This meeting has been properly noticed and posted according to law. Present, we have Chair Wendy Smith, James Robinson, Scott Walligora, Kevin Matthews. Also present is Inspector Burris and Attorney Bayer.
All right, good evening. Our agenda packet tonight has one item for review. Prior to that item, first order of business for the board is approval of minutes for our meeting on May 13th. The draft meeting minutes are provided in the agenda packet. Any suggested edits or corrections to these draft minutes? Hearing none. Those draft minutes are therefore approved. All right, moving forward to our one item on the agenda for review is listed on our agenda packet as item number 4, request to appeal the decision by the village manager on August 13th, 2025, to not enforce Village Code 225-9 pertaining to the property located at 2511 East Menlo Boulevard. To begin, I'll ask for the village attorney to provide us with the standards by which the Board of Appeals must apply in reviewing this item. Attorney Bayer?
Thank you very much. So I want to start with a 30,000-foot view, because normally the matters that come before the Board of Appeals are things like requests for variance, where we're looking at unique characteristics of a property to see if a variance should be granted from the building code. Other cases that come up on a regular basis before the Board of Appeals are appealing an interpretation of the code. This one is a little different because it's essentially appealing, or it's in reality appealing the village manager's refusal to intervene as requested in another department. So I want to start with that sort of premise. So the first question was, does the Board of Appeals have jurisdiction to hear this particular appeals application? That was the first question we looked at. My opinion is it does not, and I want to explain why. So again, the matter being appealed from, as specifically listed on the Board of Appeals application, is the village manager declining to step in and unilaterally overturn the village inspector's prior issuance of a building permit that allowed a pool to be constructed next to the appellant's property. So that's the Board of Appeals application. That's the formal paperwork that they fill out to appear here. That's what it lists. It says that it's appealing the village manager's decision to decline to step in and overturn or unilaterally overrule what had been done by a different department, the village inspector's office. So when we look at the code, there's no mechanism either in the village code, the village policy, or state statute that designates the village manager's office as an appellate body to review issuance of building permits. The village manager in reality has nothing to do with the building permit process. The manager has no duty or authority to independently review or overturn issuance of building permits. And in reality, the reason there's a village manager's office and a separate building inspector's office is that they have expertise in different areas and they handle different matters for the village. So different lanes, if you will. So in reality, if you really look at what's being submitted, the actual decision that's being complained of, or the thing that the appellants would like to have overturned, is the village inspector's issuance of a building permit back on July 23rd, 2025, to a different property owner to construct a pool. Now, again, not the appellant's property, but another neighbor's property. So what do? We look at Chapter 535 of the code. The village code requires appeals to be filed within 30 days of issuance of any such permit. There was no appeal filed. So we've got that's our jurisdictional problem. So in other words, the appeal's late. So the opinion that the Board of Appeals does not have jurisdiction is also consistent with Village Code Section 535-55, and that enumerates the powers of the Board of Appeals. So when we look at that section, it specifically references correcting errors, what it refers to as errors, in administrative orders and specifically permits, such as a building permit. So the fundamental thing that is attempting to be appealed here is the June 23rd, 2025 building permit. As I talked about earlier, the manager and the village manager's office are not part of that process. Now, it is true that the appellant sent an email to the village manager and asked her to change the permitting decision. But again, the village manager has no role in that permitting process. So if an email from a municipal official declining to interfere in another department were appealable, there'd be no rational or reasonable stopping point on what would be appealable or reviewable. Anytime a municipal action was opposed, an email to the village manager would serve to create jurisdiction with the Board of Appeals, which would be an unworkable policy and not consistent with the code. And also with that, appeal deadlines would be meaningless. The Board of Appeals, in my opinion, I've taken a look at the authority and case law and the statutes. The Board of Appeals has no authority to even order what the appellants seek. What they're really pursuing is what is known as a mandamus action. They want the Board of Appeals to direct the village manager and by extension, the inspector's office to enforce village code consistent with their interpretation of it. In other words, they want the Board of Appeals to issue an order directing the manager to then direct the inspector's office to rescind a previously granted building permit. And again, first, there's absolutely nothing in the code that affords the Board of Appeals such power. Although it talks about directing the issuance of a permit, it does not say anything about rescinding a previously issued permit, which raises another practical consideration. The property owners, the original property owners that were issued a building permit for the pool after the permit was reviewed by the village inspector, who has expertise in these areas, worked with the developer to ensure that parameters as under the code were followed and then issued the permit. The other property owners have reasonably relied upon and acted upon that issuance of the permit. And as my understanding, I think the hole's already in the ground and the pool's in. So, and finally, not, in my opinion, looking at the case law and the authority, not even a circuit court could do what the appellants ask. Long-standing Wisconsin case law holds that enforcement of a municipal ordinance is a discretionary duty that cannot be compelled through a mandamus action. Likewise, cases have held that the village's interpretation and application of its own ordinances is entitled to deference and can't be subverted through a declaratory judgment action. So the same thing holds true with respect to a municipality's decision on whether and how to enforce its ordinances. Finally, my opinion is under Wisconsin statute 78110, the appellants would probably not have standing to seek certiorari review of the issuance of the permit either. So I think with that, my opinion is that the Board of Appeals here does not have jurisdiction to hear this appeal. And my recommendation is they move to deny the appeal on jurisdictional grounds and adjourn. So that would be my, my advice. Now, if you want to hear from the appellant on that specific point, you certainly can have them address that jurisdictional issue. Then you can discuss it and decide whether to take the matter jurisdictionally. And if you decide not to, the rest is a moot point. And then if you do decide to hear it on jurisdiction, that you believe you have jurisdiction, then we can swear in the inspector. He can explain why he issued the permit and why it's consistent with the village code and why the existing pool and other items that were installed comport with the existing code. So that would be my suggestion is, you can hear from the appellant if they want to address that threshold issue of jurisdiction. And then you entertain a motion on whether to deny on jurisdictional grounds. If that fails and you decide to hear it, then we'll go on to hearing from the inspector. That would be my recommendation.
All right, thank you very much. Just for the record, I'll note that our fifth board member, Stephen Isaacson, joined the meeting shortly after Attorney Bayer started speaking. Any questions for Attorney Bayer concerning his summary of the jurisdictional question? I believe that you had said the building permit was issued in July, but I believe it was June.
Thank you.
that
If I
correct?
misspoke, June 23rd, 2025, is that
Is that
correct,
something we need to
Inspector
verify on
Burris?
the record by Inspector Burris? Does he need to testify to that?
If you,
Or
I think that they would probably stipulate to that. Because I think I remember seeing that written somewhere in the application, but otherwise you could certainly swear in Inspector Burris and have him testify to that effect.
Perhaps I would propose, and if any other board members object, that we allow the applicants, which here would be the neighboring parties, to make a statement as to the timeliness issue. Does that work?
Absolutely.
Um, Christopher Leigel,
Legal.
legal.
Thank you for the opportunity to address you. With all due respect, I have to disagree strongly with the village attorney. We were not party to any petition being issued in this case. We were not informed that a pool was going to be built next door to our house. And to attach a time limit that starts ticking at a time we're never told is just patently unfair. So to say our 30-day clock starts to tick before we're ever told that the stopwatch is clicked is just patently unfair. And I can't believe that that's what the law actually is. We were not party to that. And our complaint is not particularly with the permit being issued. And if you've had an opportunity to look at our appeal to the board and on the last page, page 5 and 6, we talk a bit about our timing of our petition. We were not part of the process. What our complaint is about the pool itself that's being constructed, that it's larger than what is allowed by the village ordinances. If this pool was being constructed and no permit was ever granted, that it was being just constructed with no permit from the village, our complaint would be the same, and our complaint to you would be the same. It seems that we should have some ability to appeal to somebody if something is being built in violation of the building code that harms us. What I'm being told by the village attorney is we have no remedy. We have no remedy at law. We have a harm to us caused by actions of the village in allowing this to be built and not stopping it, not reviewing it, and we have no recourse. We have no recourse to this board. We have no recourse to the village itself. We have no recourse to the village manager, and he's telling us we have no recourse to the circuit court as well. I can't believe that that's what the law is. I'm a lawyer myself, but I have to say I'm well out of my element in dealing with municipal law. But it just seems that this board should be able to address something like a building code violation. You may decide there is no building code violation. That's up to you to decide. But to decide we can't be heard, that's something else entirely. I think this board can review whether or not an ordinance was violated. The village has refused to hear it. Is this board going to refuse to hear it as well? And maybe the board then could tell us, where do we go? Or do we just have no remedy? A building code violation can take place. Someone could build something within a setback right up to our property line, and we can't come to the village. We can't come to you. We can't go to the circuit court. We just have to take it. If the village decides not to act, if the village decides that its own ordinances have no meaning, we have no recourse. It's up to them to decide. I can't believe that is what the ordinances allow.
Yeah,
How you doing?
For the applicant, Mr. Legal, are there any questions from the board? I'd like to clarify whether there's any dispute as to the dates and time here. So what Attorney Bayer had said was that your understanding of the permit issuance was on June 23rd.
All I can say is I wasn't part of it, so I don't know when any of this happened. Mallory and I obtained these documents from the village website.
Okay,
So it's difficult for me to say I agree to them because I just pulled them off the website.
okay.
I have no reason to question them. Maybe that's what I should say.
Okay, and perhaps I can confirm with Inspector Burris after we're done with you, but my understanding is that you first became aware of the pool when you received a text message, and was that on July 8th? I believe that's what was in your summary statement.
Yes, but I'll qualify that. I understand Shorewood has an ordinance that allows pools to be built. So we had been notified of something that we didn't have any reason to, maybe we didn't like it, but we didn't have any reason to question it. We didn't have any reason to question it until we saw the size of what was going in. So after that email, there was some period of time until we realized that what was being built was as big as it is. So we were notified, but we weren't notified of anything that we would have any reason to take action against, which is why if you look at the packet we submitted with our appeal, our first letter to the village board, which was who we thought we probably should contact, that's who we thought of. The village attorney is telling me that that's inadequate, that wasn't the person we should contact, that the village doesn't act as a single body, that we have to identify the specific person and get our document right to that specific person. But our first letter to the village board member was, shouldn't we have a chance to be heard? Why weren't we told? And that was our complaint. My understanding is that the ordinance doesn't mandate that we be told. So it wasn't until later that we realized that this was bigger than we thought it was allowed.
And then the dates as to your communications with village manager Ewald, I have it listed as August 13th is the most recent email.
I would have to look. We exchanged a few emails with her, and I think we included all of them in our appellate packet, and I just don't remember the exact date. It was within a very short period of time. I mean, no more than 3 days, probably just 2.
Okay, and but the dates you expressed in your statement submitted with your application are your understanding of what's true.
Correct. I have no reason to believe that any of those dates are
Okay,
inaccurate.
I don't mean to put you on the spot and grill you about dates, but I just wanted to make sure there wasn't any dispute as to the timing before we consider.
Well, and I just want to say
This is Mallory.
too, that on July 17th, when I met with, I asked, is this something we should take to the Board of Appeals? But there was, we thought, we don't need to take it to.
Okay. Any questions for Mr. Legal or Ms. O'Brien? Okay. Any further statement you'd like to make at this time, just on the jurisdictional question about timeliness?
No, I think the board could hear the merits of our.
Attorney Beer.
Thank you. Just a couple of follow-up on that. There was some consternation about the policy of, who has standing to challenge issuance of permits. There's nothing new about this. I'll give one specific example of state statute. 78110 deals specifically with review of any permit or authorization for building, zoning, driveway, stormwater, or any other activity related to a residential development. So in other words, a permit for anything related to residential development. And it governs specifically circuit court review of those decisions. And review of that is limited. The only people that can challenge the issuance is under sub 3 is somebody who submitted the application, somebody who has an ownership, or someone who has an ownership in the property that's a subject of the application, or someone who sustained physical damage as a result of the issuance of the permit. In other words, they issued a permit and they accidentally went across the line and, damaged something next door to it. So there's precedent for this even in state law. And again, the problem is twofold. One issue is that there's no review of the underlying decision to issue the permit because we're past the 30-day threshold. But the second issue is what's purported to be appealed here is the village manager simply saying in response to an email, that's not my lane. I'm not going to interfere. I'm not going to intervene with a decision that we believe was properly made by the inspector's office in issuing the permit in accordance with, the law. And if that, in my opinion, there's no precedent for that. The ordinances don't contemplate it. The statutes don't contemplate it. Nothing in the case law they even look at contemplates that. And I think that's the problem. It would be a bad precedent. It would be setting a bad precedent moving forward. So I think, again, my recommendation is that the body entertain a motion to deny the appeal on jurisdictional grounds. If the body feels that it does have jurisdiction, and then I think then we can swear in swear in the inspector, and then he can explain it, and then we can move from there and treat it as a normal appeal. So at any rate, that's my advice to the body.
So I have a follow-up question based off of Mr. Legal's statement that if we were to find this to be untimely and that there is no jurisdiction, applicant asks us to still consider the matter,
Mhm.
maybe based off of arguments of fairness. Does a municipal body like the Board of Appeals have the authority to waive jurisdictional rules? If this is untimely, can we even hear the merits?
That
Because we
hasn't-
think it's
yeah.
unfair.
I did look at 535. I looked at the code. There's no reference to that. I do think that if the village stipulated to it, in other words, if the inspector's office stipulated to it and the applicant stipulated to it, I think then the body could hear it.
So if
I-
the village were
I
to
mean,
waive the jurisdictional
Yeah, I
question?
mean, I think certainly the village, if the village would do that, I think it raises the question then, what would the standard be to establish hearing the appeal that was beyond the jurisdictional period? But I think, it would, in other, in circuit court, it would be, would there be just cause, that you could potentially apply the standard from a default setting. I don't know exactly what that would be, but sitting here right now, we'd have to figure that out. But I think though there's a twofold problem. The first problem is if you are going to appeal the underlying decision to issue the permit, the time to do that has passed. But the second problem is, setting that aside, the item that's identified as being appealed from in the paperwork is the decision by the manager not to intervene and essentially overrule the decision made by the inspector's office. And I think, again, that that's a bad precedent to set if we say that we're going to review the village manager's decision to decide not to get involved and do something extraterritorial, if you will, or outside the normal jurisdiction that would be afforded to the village manager's office, and go back and essentially direct the inspector's office to interpret and enforce the code in a different way. I think that's unworkable as well. So I see the jurisdictional problems as twofold. One, there's a 30-day problem with the underlying issuance of the permit. And secondly, when we're analyzing it under what was actually submitted, which is they claim they're appealing the village manager's decision not to get involved, I don't think that's reviewable either. So I think it's twofold.
Question?
I have a couple questions. Is there any authority in the ordinances to enlarge time under any circumstances at all?
It doesn't, there's no reference to that in the ordinance.
Okay, and
I
then,
can't say that it's never, ever happened in the history of the village. I don't know that. I don't remember it ever happening in the time that I've worked with the village. But, again, I think that if the village stipulated to it through the inspector's office, I think jurisdictionally that would be fine. But absent the inspector's office saying we waive any jurisdictional arguments and stipulate that it's timely, then I don't think there's any provision for that in the ordinance.
all right, and then my other question is that the action by to issue a permit, that's under like the village's executive power, correct?
Well, what do you mean by executive?
So like
power?
the body that issues the permit, that's the village manager's office, like this is the legislature, and we have the judicial branch and the executive branch. Under what authority are permits issued?
By the village inspector's office.
Okay,
Yeah,
and that would
who
be probably
is-
like, 'cause I guess my concern is like if we agree to waive the time limit violation, that we're still stepping all over the democratic process because of the separation of powers issue. This is not necessarily the right body to review a decision, even if it was within the time limits, it sounds like.
I think that's a good way of putting it, because the problem is the village manager is saying, look, that's why we have an inspector's office. That's why we hire someone who has specialized knowledge, skill, training, and experience, and has taken tests and passed tests on, the state codes and the international codes and the building codes and how they apply and how they work. I'm just the manager. That's why I would hire somebody else to do that. That's why we have a development department. So you know, so that puts this body in the difficult position of being asked to review a decision by the village manager to say, I'm going to stay in my lane and not get involved in this because that's not what I do.
So the village manager referred this to the Board of Appeals. That's where she thought the jurisdiction. And you're saying it's not. How come she did that?
I can't speak for the village manager other than to say it would be normal for somebody to say, you know, hey, if you've got a problem with the municipal decision, take it up with the Board of Appeals. In general, that's a true statement. In general, there are a lot of matters that come before the Board of Appeals. Having not been involved in the day-to-day workings of, you know, how many permits on any given day, there's all kinds of permitting questions and requests that come into the inspector's office. You know, I'm sure she didn't know when it was issued, what the deadline might be. You know, and just a generic, you know, if you've got an issue, this is the body that we have, you know, in the village, we have a Board of Appeals. Go ask them, you know.
But you're saying, I'm sorry. if
Yeah,
my-
yeah, go ahead, yeah. No worries.
You're saying, if I heard it right, that the Board of Appeals is not the body to hear this. It sounds more like a court issue, not us. And that her referral here was erroneous procedure.
Well, I don't know if I would call it erroneous to generically say, look, you know, if you have an issue with a decision that was made by a municipal official here in some other department, generally speaking, the Board of Appeals is the area where you could seek relief, assuming, presumably, that you meet all the other jurisdictional requirements, including the 30-day window, et cetera, et cetera. So I don't, you know, I wouldn't expect her to say, well, you know, I'm going to do an independent investigation in it and determine whether, independently determine whether there's jurisdiction or not. I'm just going to tell you generally, we have a Board of Appeals. And I think that's appropriate. And I think the fact that she didn't know all the gory details about when the application came in, when the permit was issued, demonstrates the point that there's an inspector's office with specialized knowledge, skill, training, and experience that handles these. And then you have a manager's office, which deals with, you know, which is sort of your CEO of your multi-million-dollar corporation, who's dealing with budget and bigger picture items. That's not involved in the minutia of daily things that go on, and a different department is not micromanaging another department. I don't think it's inappropriate to say, hey, generally we have a Board of Appeal.
But you recommended that this is not the body to hear this. Is that what I heard? I mean, I didn't catch every word of
Yeah,
yours.
yeah. So again, I think my opinion is, okay, let me go back to the beginning because I think you missed the very beginning.
I did.
Okay,
Sorry. Apologies.
that's okay. The Board of Appeals application, that's the paperwork through which the appellant says, this is the decision I want this body to review. That paperwork filled out by the appellants identifies the thing that they are appealing as the village manager's, this email chain with the village manager, asking or demanding that the village manager unilaterally somehow, which he doesn't have the power to do, overturn the village inspector's prior issuance of a building permit that allowed a pool to be constructed next door to them. That's the thing they identified as we are appealing. Okay. My opinion is the village manager merely responding to an email chain saying, I'm not getting involved. That's the inspector's office. That's their lane. That is what they do. That's what they're trained to do on a daily basis. That's their expertise. I'm not going to interfere in that process. The permits have already been issued long ago, and that process has moved along. I think the pool's already in at any rate. So I think that sets a dangerous precedent. If that decision is reviewable, you could theoretically send an email at any point in any time to the village manager or other department head and say, hey, I don't like what happened here 6 months ago or 9 months ago or 3 months ago or 2 weeks ago. I want you to step into that department and overturn that decision and change it. If that official, the department head says, I'm not getting involved in that, now we've created a precedent where that's appealable to the Board of Appeals. I think that's a bad, my opinion is the Board of Appeals doesn't have that authority. I also think it's a bad precedent to set. And I also think looking at the power more broadly, not even a court, not even a circuit court has the power to tell retroactively a village how to interpret and enforce their own codes that are of local interest. So matters of local interest. Courts have generally said we're not going to get involved in that. I also use the example of 78110, which talks about a review process for any permit or authorization related to building, zoning, et cetera, on any residential development, any permit associated with that. Even the state statutes for circuit court review has very, very strict jurisdictional grounds, and you can't appeal it unless you're the person who submitted the application and got denied, or you have an ownership in the property, or you have a documentable damage as a result of that. So this isn't just made up. I mean, this mirrors essentially what the state legislature has done at the state level to create barriers or standing, if you will, for people to review these types of decisions. So that's my opinion. That's why I don't think that this body has jurisdiction to hear an appeal that says, well, I asked the village manager to intervene and she refused. I don't think that falls within what this body has jurisdiction over. Does that answer your question?
It does answer the question, and you're also saying that these folks have no remedy because they're not owner of the pool,
Well,
involved in the construction process.
well, again, I'm not a judge, right? I'm telling
Understand.
you but my opinion is, I'm using by analogy, I've also looked, because I wanted to see if there was any precedent. I also looked at some of the case law and some of the state statutes. And, look, I mean, obviously the appellants would have the right to seek either certiorari review or whatever other review they think is appropriate. In circuit court, obviously the village's argument would be that there is no, that would have to be dismissed for the reasons I explained, but, they're going to do whatever they're going to do, and that's fine. But I think for the purposes tonight, my opinion is that the Board of Appeals does not have the authority to review the village manager saying, I'm not going to get involved in that, because then what do we do? What would the order be from this body? This is an error correction body. And so what would it do? How would it tell the village manager, well, you made a mistake? It doesn't have the power to direct the village manager to go back and then tell the inspector's office to do something different either. So it's a non-starter, even if we find that there's some kind of jurisdiction. So I think for all those reasons, it's essentially a non-starter at the Board of Appeals.
So the purpose of the board, at least as long as I've served on it, most of the time, all of the time, we are looking for variance building.
That's correct. Yeah.
That's pretty much it.
Mhm.
None of that exists.
Well, that's correct. But though, I want to be clear though, to be fair to the applicant, the Board of Appeals has jurisdiction over more than just variance requests. If I hypothetically submit a permit to the inspector's office to build a new garage and they deny it, and they say, well, it's because you are too close to the lot line or whatever it might be, you're violating the existing code. As the person who got rejected, I have due process rights, and I can come here and say, I think that the inspector just made a mistake in interpreting the code. I can bring in an expert. I can bring in my developer, whatever. I can argue that. But generally speaking, there's extremely limited review and there's very limited standing to challenge that decision to issue if you're not the person who requested the permit in the first place. That's what 78110 says.
And that's kind of what I would.
Exactly. Gotcha.
Any other questions for Attorney Bayer this time?
Yeah, I have a question about the notification process relative to the June.
Mhm.
Was there any requirement?
I don't believe under the code. Now, there are certain developments and construction that does require. I'll turn it over, if I may, to Inspector Burris and have him answer that question.
Uh,
Is there any,
Is he going to be attesting to facts?
I just don't know. I don't know what the code says. Do we require them to send out notices on a permit application for a
And
pool?
Inspector Burris, we may have questions for you concerning the facts of this case.
Mhm.
So can I swear you in, please?
Inspector Burris, do you attest that this testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. The village code does not require notification for the construction of pools. Notification is required for the construction of new dwellings, additions over 200 square feet. That's when notification is required.
Can you walk us through the process of what an objection would have looked like had it been brought timely? Just because I'm kind of curious as to what that process even looks like. I just want to.
Sure. So as Mallory indicated in the materials that were provided, she did come into the office on July 17th and inquired about what could be done. And as I explained, that we had reviewed the permit application, that it met the requirements of the code, and that we had issued the permit.
Another question, and this actually might be for you too, Attorney.
Sure.
Counselor, when somebody's application meets the requirement, what sort of discretion do you have? Like, you know, if they meet the requirements for a permit, does it say shall issue the permit, or do you have some discretion to deny a permit that's otherwise valid based on all of the factors that you consider when making that decision?
There's case law that says if you submit an application for a building permit that comports with applicable zoning and the building code and it's denied, you have a property interest in that, and that you can sue to get it, basically to compel it to be issued.
So like,
So
long story.
you can't just say, well, you know what, you meet the code, but we don't really like it. So no. I mean, that,
You're kind of required. If it meets all the
Yeah,
checks, all the
yeah.
boxes, you have to issue it. You don't have any discretion in saying, oh, okay.
Yes.
So I thought, I just wanted to be clear.
And if I may, just to the point of, this is not the first pool that has been installed in the village of Shorewood, and the review in how we conducted the review with respect to the area of the pool was consistent with all previous pools that have been installed.
Okay, and just to confirm the timing facts as to the issuance of the permit, that occurred on June 23rd?
That is correct.
Any further questions for Inspector Burris? Applicants, do you have questions for Inspector Burris? If you are going to speak, if you can speak into the microphone so that we can capture it on the record.
I've not been granted the opportunity to address the merits.
And I don't necessarily want to get into the
No,
merits.
and I don't want to get in the merits, but I just want to object to Inspector Burris stating this is consistent with how other pools have been approved in the village, because that gets to the merits of our case. And I do have some things I'd like to say about that, which I had been prepared to question Mr. Burris about, but I don't want to because I haven't been able to get there. So I object to that, and I would ask the board not to consider that, because I think there's some complexities to that. I don't think he's lying, but I think there are some complexities to that would be worth probing if we ever get to the merits. I don't have a particularly clear understanding of what the village attorney is saying. My understanding of what the village attorney is saying is that the inspector's decision is not challengeable. That can't possibly be the case. My understanding is the village attorney answers to the village manager. The village manager is the village inspector. The village inspector answers to the village manager. When we got a decision from Mr. Burris that we didn't agree with, it was appropriate for us to go to the village inspector's boss and say, we don't agree with what your employee decided. So that's why we went to the village manager. The village attorney is saying, no, you can't do that. The village manager can't overturn the village inspector's decision. That can't possibly be the case. The village inspector is not infallible. Somebody, presumably the village manager, can challenge his decisions. And we went to that person and asked that person to review his decision, to change his decision. She told us to come here. And here we are. and to tell us that, we believe here's the trajectory of how I see this from our perspective. The inspector makes what we perceive to be a mistake. We have no idea that he's made that mistake because we're not part of the permitting process. So we have, and as has been discussed, we're given no notification. We have no idea that this has happened. Time goes by, a month goes by. This time limit was set for some reason to give adequate time for people to consider it and raise an objection. But our clock is ticking. We don't have any idea. We finally get pool progress started. Now, in our appeal, you can see, and this is the merits, and I don't want to get to it, that we have some problems with the plan, that it doesn't match what actually went in. So we can't even look at the plan and say, this is what's going in. We have to use our eyes and watch. And as we see what's going in, it doesn't look like it should be there. It looks too big for the property. So we do our own research, and we determine that this thing in our calculation, which you may decide is wrong should we ever get to the merits, but we decide it's too big. And so we do what we do when we go to Mr. Burris. But this is just patently unfair. We should be able to review Mr. Burris's decisions with his boss and ask his boss to take action. And the village attorney is saying, no, you can't do that. I don't know who I'm supposed to bring my complaint to. Mr. Burris? He's already told us everything in his opinion is okay. So this process is absolutely unfair to us. I understand that the Rolfsons got a permit and they want this pool. Well, we don't. And our property is not of lesser value or of lesser import than theirs is. Our interest in enjoyment of our property is not less. This project affects us. This is not someone putting an addition on their house where ultimately it doesn't have any real effect on us. This has a major effect on our property. And we should have an ability to be heard here in our village where we pay taxes in some way to say what the village granted hurts us. And I, quite frankly, don't understand the village attorney's analysis. I don't understand. I'm trying to follow it. I'm trained as a lawyer. I've worked as a lawyer for 30 years. I don't follow it. It doesn't make any sense to me.
I have a question.
Any
I have a
questions for Mr. Legal?
Well, not for so much applicant, just general. So there are occasions, somebody been living in it for years, property. There are somebody builds an apartment. In my mind, really no difference. You have a pool, I get that. Could have been a building blocks out the sun and yard, but it applies with the village code. And so the question is, when that happens, what is the appeal process? What can the neighbor do? If the code has been met, you can put up a 12th Street. And it affects ambiance person. What are the remedies?
So a couple of things. There's that specific example you gave is going to probably be covered by easement law. There's a specific Wisconsin Supreme Court decision, I think it's from the 1940s, that talks about light easements. And so that's sort of a special case. But that's a different area of law. So I think the important thing is to remember, okay, it wasn't improper. It certainly was not in any way, shape, or form improper to talk to the village manager and say, hey, I think somebody made a mistake here. That's fine. There's certainly nothing wrong with that. The village manager looked at it and determined that correct decision has been made and I'm not going to intervene. Fine. But that's not what this is about. Everyone is impugned with knowledge of the code and the law, and we have a code here in Shorewood, and it says a couple of things. If you want to appeal the actual decision or you want to appeal the decision by the village inspector to issue a building permit, you got 30 days to do it. Okay. That 30 days came and went. It doesn't matter whether you know about it or not. It is what it is, right? So that time came and went. That's not what's claiming to be appealed here. What they're claiming to appeal is this email chain with the village manager that says, hey, we think you should step in and intervene. We think you got it wrong. You should, you should overturn that decision. Okay. And the village manager said, I'm satisfied with the work that was done. I'm satisfied that the inspector's office got it right. Take it up somewhere else. I'm not going to get involved. I'm not going to overturn. That's the decision. So what exactly authority would the Board of Appeals have if they were going to entertain that? It wouldn't have any authority to direct the village manager to go turn around and then direct another department to take certain action. It's totally unworkable. That's not a reviewable decision by the Board of Appeals. And again, the point that I was making through my examples were the circuit court wouldn't even have jurisdiction to do that, in my opinion, either, because of 78110 and the other case law that says the manner in which a municipality interprets and enforces its code is not something reviewable on a declaratory judgment action or certiorari review. So the inspector's office made a decision. It had the specialized knowledge, skill, training, and experience to interpret the building code, believed that the code was comported with, and it issued the permit. Okay? And unless, again, unless there's physical damage to another's property as a result of this, they brought in the earth moving unit and they went over the lot line or something, there's no standing. There's no standing for
So you're saying the 30-day period was critical? 30-day.
that could have been, they could have, on a theoretical level, they could have challenged the issuance of the building permit within 30 days. Okay, they didn't do that. What they're appealing, though, is this email chain with the village manager where the manager says, I'm not going to get involved. That's,
So I guess I'm having a little trouble with whether or not relying on the village manager to take action was reasonable in these circumstances. But let's just say that we decide that it wasn't and that there's jurisdiction.
Mhm.
What's the remedy here? And who's going to pay for the removal of the pool? Because it sounds like that's what people are going for here. So for all of citizens don't pay for the removal of the pool. The village certainly shouldn't be responsible for paying the removal of the pool. Doesn't sound like that anybody did anything wrong. And so there's really no way to undo this because there was nothing that was done incorrectly. It's unfortunate that there's neighbors who disagree with the decisions were made and the way the democratic process worked, but this isn't necessarily the forum to address those issues.
well, I don't want to get too far ahead and I don't want to presume, anything further than what we're talking about, but you do pose or you do point out a big problem is, okay, what are we actually reviewing? What's the actual decision that we're going to be asked to overturn? This body would be asked to overturn. All of you asking that question to yourself, what are we being asked to overturn? Well, the village manager said, no, I'm not going to get involved. Well, what would we be then directing the village? What would this body direct the village manager to do? I mean, what would be the remedy? We'll look at it again. Well, we can't put the genie back in the bottle, right? So would it direct the inspector's office to take another look? They've already done that 3, 4, 5 times at the request of, everybody that's been calling and the appellants. The inspector's office is firm in its decision that it properly issued the permit. So the inspector's office has already made its decision. The manager's not going to rescind that, can't unilaterally rescind that under the code. So even if we reviewed the manager's decision to not get involved, where does it take us? What remedy would this body craft? None.
I have a question. So if they had been notified within the 30-day, they had 30 days to appeal what would their remedies have been at that? Before it even got here, what could they have done? I don't want this thing against a building permit was issued. We don't think that's valid. What are the remedies before it gets to? If they would have, because the time period came and went,
Right.
but
Right.
let's say it didn't, what could they have done?
Well, if an appeal had been filed within 30 days, they could have said, we disagree with the inspector's interpretation and application of the code. And then made that argument, you know, and then,
Does it come to this body at that point?
yeah,
or-
that could have come to this body within the first 30 days after issuance of the permit. Absolutely. And then the issuance of the permit would be under the jurisdiction of this body.
There a waiting period from when the permit was issued to when construction of the pool began? Yeah, I'm just curious because, you know, it's appealable within 30 days, but if the pool was erected overnight, that 30-day appeal period doesn't really afford any opportunity to be legitimately heard.
Well, generally speaking, the purpose of the Board of Appeals is for the person who applied for the permit to say, hey, wait a minute, I didn't get a permit. I should.
Mhm.
I was entitled to one. In fact, that's why the legislature passed 78110, because they got tired of hearing essentially certiorari reviews from people that were not actually issued the permit. In other words, neighbors complaining that, hey, a permit got issued over here. So they changed the law. They changed 78110 to basically make it extremely difficult unless you were the appellant or you had a property interest in the property to which the permit was subject from even going to court and saying, hey, we don't like that. So the state legislature said, we're done hearing those basically and changed the law. We're probably, you know, I've recommended we change the jurisdictional requirements of the Board of Appeals to match the state statute, which we well wouldn't be here, but right now, but the language used in the existing ordinance is extremely broad and says basically anyone aggrieved or perceived to be aggrieved by a decision of the municipal body can apply to the Court of Appeal or the Board of Appeals. You know, can appeal to the Board of Appeals. So the jurisdictional language is so broad that, yeah, I do right now, the way it's written, a neighbor could say, well, I don't like the fact that you issued a permit down the block
As long as within 30 days, they could appeal. to
within the
board.
30 days.
Okay, so then I guess just like a hypothetical, if like they appeal, but the pool, you know, what happens if they appeal, but the pool has been constructed and it all happens within 30 days? Pool goes up in 7 days. 10 days later, we're in front of the Board of Appeals and the Board of Appeals reverses the issuance of the permit. Then what would the remedy under that very weird circumstance
Yeah,
be?
yeah. Well, the individual who was issued the permit, it's up to them, you know, they can move forward at their discretion or risk if they want, you know, we've seen that. There was a lawsuit challenging the development on Capitol Drive. By the time it was dismissed, there were people living in it. You know, I mean, the suit got dismissed, but in fact, if that suit had been filed now after the change in the law, they wouldn't have had standing. So, but yeah, I mean, within 30 days, you know, the way it's written now, you could appeal the issuance of a permit to somebody else.
Okay.
But, I mean, the hypotheticals are helpful in understanding, but in this case, it seems undisputed that the applicants were informed of the fact that a pool was going in and digging was starting tomorrow on July 8th. And that was within the 30 days period of time to lodge a application with the Board of Appeals. So, like, I understand that the applicants were seeking other maybe informal or alternative routes for resolution, but my understanding, and maybe Attorney Bayer can confirm, that just the plain text of the ordinance, the timing starts from the date the permit is issued.
That's correct.
Is that correct? Okay. Other questions for?
Is there a
Attorney Bayer?
requirement to notify the neighborhood that a permit?
No.
For other types of construction there is, but not this. I think you said it was above additions of 200 square feet or more and some other things,
New construction.
new construction.
Any further statement from Inspector Burris as to timeliness?
All I will say is that it is, it's not, and again, when Mallory came into the office, I do not advise people to appeal decisions or not to appeal decisions. So I did not deny anyone the opportunity to Board of Appeals that would have been within the 30 days.
All right. Is there a motion to take this under consideration amongst board members? Second?
Second.
Okay. Does anyone have any preliminary thoughts as to whether there is jurisdiction to hear this appeal? Go
I
ahead.
don't think that this board has jurisdiction just based on the fact that it happened outside of 30-day period. Now, that being said, the thing that we're being asked to appeal is, I don't think falls within our purview and just seems to me to run afoul of separation of powers. And then lastly, there is no workable remedy here. It's unfortunate that the applicants are unhappy that progress is moving on next door to them, but that all fell within the tried and true democratic process here. And we are not a body that's just, I think, in a position or have the authority to go and walk those decisions back. We had a lot of well-intentioned people follow these processes that were laid out and follow them to a T. And so I don't know that us taking this up is going to do anything but make this an even bigger mess.
I would say that there should be best practice. Seems to me that the right thing to do is to notify people in the neighborhood as soon as this was approved, so that, and then told you have a 30-day period to appeal, so that it's crystal clear what your options are. My feeling is that, based on the discussion, 30-day ship had sailed. Don't think it will, but I'm sympathetic to this situation. I think maybe I would recommend better best practice.
Any further statement or comment? I'll say that generally, it doesn't sound as though there are facts at issue here. And if we have guidance from the village attorney about a question of law, about jurisdiction, I'm inclined to follow the guidance of the village attorney, finding that there's no jurisdiction for this appeal, both on the grounds that the 30 days has expired from the issuance of the permit and that we don't have jurisdiction to review this inaction of the village manager. You know, I don't feel comfortable making legal determinations on behalf of the Board of Appeals. So if the village attorney tells us that his guidance is that it's not timely and not within our jurisdiction, I'm inclined to follow that guidance. Is anyone prepared to make a motion? Attorney Bayer, is there any, how specific do we need
Yeah,
to be about crafting a motion?
I think you can just reference for the reasons discussed on the record, move to deny the appeal on jurisdiction.
Would anyone like to make that motion? Or shall I? I move to immediately forget what you just said.
For the reasons discussed on the record, move to appeal on jurisdiction.
For the reasons discussed on the record, I move to deny the appeal on jurisdictional grounds. Is there a second? Mike, can you call the vote? You could just go name by name.
Wendy Smith,
Aye.
Stephen Isaacson, James Robinson,
Aye.
Scott Walagora, Evan Matthews.
Aye.
Motion passed. The appeal is dismissed. With no further items on our agenda, this meeting is adjourned. Thank you.